A Cape Coral father is speaking out after a judge ruled his then 10-year-old son made a school threat via text.
Daniel Marquez said that the texts were a joke about a scam involving money and guns. He then referenced a school event. Wink News investigative reporter Celine MacArthur has been leading our coverage of this case and joins us now to explain the verdict.
Daniel's father says he doesn't understand how Judge Carolyn Swift came to her decision. After close to 3 hours of testimony, she found Daniel Marquez delinquent. That's the term for guilty in juvenile court. Guilty of sending a written or electronic threat to kill, do bodily injury, or conduct a mass shooting or act of terrorism. The state had to prove the person sending the texts recklessly disregarded the potential that the person receiving them would feel threatened. She said they did.
Based on the totality of the circumstances, the credibility of the witnesses, including the credibility of Mr. Marquez, who took the stand today, which the court finds, quite frankly, he was not transparent with the court, not to be understanding that his age, but he was overly coached, and I don't find his testimony very credible, which is my purview to determine.
Judge Carolyn Swift came to that decision shortly after prosecutor Scott Miller challenged Daniel's explanation that he was joking about a scam to his friend. Daniel testified that he didn't know about the mass shootings at Uvalde at the time and that it didn't inspire his texts.
Were you all aware that the Uvalde school shooting happened?
No.
You hadn't heard about the school shooting that happened just days before?
No, I didn't really watch.
Daniel's friend's father, Caesar Saparitis, took the stand. In his text to Daniel and his call to police in May of 2022, he referred to the texts as inappropriate. In his court testimony, he described them differently.
What were you worried about?
Concern about being real because of what just happened. You know, we are in high alert.
Of what being real?
The threat.
The threat of what?
Of a mass shooting or school shooting.
And why did you make the decision to call law enforcement?
Because if there's anybody who can know if it's a real threat, it's the sheriff department or any authority will know.
Did you at any point tell him that you felt that he had threatened your child?
I did not say that, no.
The prosecution also introduced new evidence. We couldn't see it, but it was described as images of Uvalde, Parkland, and the song Pumped Up Kicks. The LCSO digital forensic specialist says she pulled them from Daniel's phone months after his arrest.
So at this point, can you tell, based on these images, whether they were individually downloaded by Mr. Marquez?
No. We objected to all of this because what's interesting is they were able to tell that these images were somehow on the phone, but by the state's own witnesses, they couldn't explain how they got on the phone. In fact, they went as far as to say that those pictures could have come out in any number of ways. There's no evidence that Daniel searched for them, downloaded them, sent them to anybody, or had anything to do with it.
I spoke to Daniel's father, Derek Marquez, after the verdict.
To me, it just doesn't make sense. But again, I'm not a lawyer. I'm not a judge. I didn't go to law school, so I don't really understand how that conclusion was arrived.
Daniel is due back in court in August to learn his punishment. Alex Saiz, Daniel's attorney, is already working on their appeal. He argues the judge abused her discretion in this case. In juvenile court, there's no jury. The judge weighs the evidence and makes the final call. I'll stay on top of what happens next. Back to you.